Landlords should be aware of their obligations going forward and the potential fines that they could be subject to for breaching the terms brought in by the Renters' Rights Act. The Renters' Rights Act 2025 came into force on the 1st of May 2026. There are a number of changes for both landlords and tenants. Importantly, all tenancies that were assured short-hold tenancies are now assured periodic tenancies. That means that they roll from month to month, and there are different rules about how tenants and landlords can bring them to an end. There are some important deadlines that landlords and agents need to be aware of. All landlords and all agents need to provide an information sheet that's been published by the government and can be found on the government website pages to all tenants by the 31st of May, and failure to meet this deadline could result in fines. If your tenancy is not in written formats, you also have to provide certain written terms to your tenants before the 31st of May. Another important change was the removal of Section 21 evictions. For those that don't know, Section 21 was the way in which landlords could evict tenants from properties without having a reason. Going forward, landlords will need a reason before they can evict tenants from their properties. The reasons that landlords can bring tenancies to an end have changed slightly. There's still rent arrears as a ground for possession. However, the requirement for rent arrears has increased to 3 months from 2 months. And there are some additional grounds as well. If a landlord or a close family member want to live in the property, or if a landlord wants to sell a property. The other significant changes for landlords in the private rental sector are, for example, there's now a right for tenants to request that they can have pets at the property. Landlords can refuse, but there are quite limited reasons. Also, landlords can't unfairly discriminate against people who are on benefits or have blanket bans. Another point that landlords need to be aware of is that any rent review provisions in tenancy agreements will no longer be effective. So if a landlord wants to increase the rent at any point, then they need to go through the statutory procedure, and that has changed slightly. If you have a query related to any landlord or tenant issue, then I recommend that you obtain formal legal advice. As a really good starting point, any ARAG policyholders should contact our legal advice helpline for initial advice, and they will be able to point you in the right direction.